Hello, welcome to the fourth lecture in the first unit of the class. This is going to be the last one before first exam, and I apologize for the delay. That weather was pretty crazy, so thanks for bearing with me, and we will get through this together. So anyway, I wanted you to get to know, this is Chapter 4, Supreme Court and the American Judiciary, and it's one of my favorite topics in everything I get to teach. I love the Supreme Court. This is a picture of the current U.S. Supreme Court and all of its members. You can see that they're so happy and so excited to be there. Just to point out who these folks are, we have Sonia Sotomayor. We have Breyer. We have Alito. We have Kagan. We have Clarence Thomas. We have Antonin Scalia. We have John Roberts, who is actually the Chief Justice. So I'm going to say C.J. Roberts. We have Kennedy, no relation to the other Kennedys. And we have the very tiny Ruth Bader Ginsburg. And these are our 9 members of the Supreme Court. It doesn't matter who these individuals are. But the fact of the matter is, to decide a case, the Supreme Court, there are 9 of them. So 5 of them have to decide to make a decision. So if you can get 5 people on your side in a 5-4 decision of the U.S. Supreme Court, you can change the meaning of the Constitution. You can change the understanding we have of the government. So if you can get any 5 people on your side, you can really have something. We've seen a lot of changes over the last few years of the Supreme Court. Our previous Chief Justice, Rehnquist, who I'll talk about in a little bit, when he was Chief Justice, the same 9 people were together for 13 years on the U.S. Supreme Court. That hasn't been the case in the last few years. We've seen a lot of change. This is a picture of John Roberts with his little boy. When Roberts, you can see here, he's the new Chief Justice. He's getting sworn in. This is Samuel Alito on the verge of him getting sworn in. Here's a nice picture. I wanted to show you what the Supreme Court's judicial conference room looked like, and this is the room that they go into to make their decisions. We'll talk more about conference in a minute. But this is President Bush on the occasion of the appointment of Chief Justice John Roberts. So there they are, and they're all in the conference room looking all spiffy and happy. And other recent changes we've seen, President Obama has been appointing 2 judges lately. He just appointed Sonia Sotomayor to replace David Souter. And then the other new judge is Elena Kagan that is going to replace Justice Stevens. All right, so this is slightly out of date. Let me update it just a tiny bit to say that we don't have Stevens anymore. And the new judge is Elena Kagan. And like Sotomayor, we really don't know where she stands on things. We don't know if she's going to be more liberal and vote with these folks. We don't know if she's going to be more conservative and vote with the conservative group. But look at this. You have to have 5 votes to make a decision. There are 4 extremely solid conservative votes here on the court. Kennedy usually votes with the conservatives. So until these 5 people are no longer on the court, most of the decisions are going to tend to fall in a more conservative direction than in a liberal direction, because you have to have all 4 of the liberals plus, or you'd have to have so you'd have Ginsburg and Breyer, perhaps, Sotomayor and Kagan. Now, Kennedy is the one who usually goes to the right. If he decided that he wanted to be more of a liberal on a certain opinion, then he would really make the difference. A lot of times when judges or when attorneys are arguing a case in court, they don't argue for the whole court. They argue for Kennedy, because they realize that if they get Kennedy on their side, they've turned the entire court. Okay, so one of the major Chief Justices we've seen in the last few years is William Rehnquist, and he was the Chief Justice between 1986 and 2005, and he made a huge mark on the court. He's a very conservative judge, and he really moved the court in a more conservative direction. The justices are appointed by the President and confirmed by the Senate, and they serve for life. Once you're on the federal court, you are in for life. So presidents try to appoint judges who are as like them politically as possible because they want to, you know, if you're the president, you only serve for 4 or 8 years. But if you put a judge on the bench that serves for 40 years, then you've extended your reach for a really long time. So presidents tend to pick the judges who are most like them, who they think the Senate will confirm, and young people, you know, relatively speaking, 40s and 50s, so that they will serve for 40 years and really make a lasting impact. So one of the major questions we have in our democracy is it better to have elected or appointed judges? This is a really tricky question, and in fact, John Grisham, if you like John Grisham novels, he wrote a book called The Appeal. In that book, a powerful company in Mississippi basically purchased, on the basis of campaign contributions, a seat on the Mississippi Supreme Court. And because the judges were elected, well, he was bought and paid for, so that company got anything it wanted to. So if you have elected judges, they are very responsive to the people, but so much so it might be too responsive. Now, an appointed judge could get on there and, you know, be a judge for 50 years and be completely divorced from what the people want, and that's not good either. So it's not really good to have elected or appointed judges. A good mix is often the case we want to go, the way we want to go. The U.S. Supreme Court has an average retirement age of 78 years old. So you can see if we have appointed judges, they're sticking around for a really long time. And the current average age is almost 80. Interestingly, we've seen almost all judges being Protestant, but right now on the court, there are no Protestants. It's all Catholics and Jews. So there are no Protestants on the court right now. We've seen 2 African Americans. We've seen 3 women. Most of the judges have been educated at top law schools, meaning they're all from Harvard or Yale or Chicago or Stanford. They're all coming out, no matter where they're coming from, rich, poor, black, white, male, female, they come out and they've all been taught the same stuff. So having been to law school myself, I know that it's a very difficult indoctrination experience, and everybody comes out looking the same on the other end. So no matter how much diversity we might see on the court, it doesn't matter as much as people who serve from top, not just the top law schools, but law schools that might better represent all people. And right now, every single judge on the court went to Harvard or Yale. That's not too cool. There are 2,000 schools in the United States, and a lot of law schools. You don't have to just go to Harvard or Yale to be worthy to be on the court. This is just I just dug this up. I thought this is interesting. Much like we looked at members of Congress and how much they had financially, you can see that most of the members of the U.S. Supreme Court are quite wealthy as well. Many of them because of their spouses. But like David Souter, who had family money, Ruth Bader Ginsburg's husband's really, really rich, Breyer's rich. I mean, these folks, this is their annual income. So, woo, $5 million? My goodness. Okay, and at the idea of appointed versus elected, Oklahoma has found a way to blend this system, and it's called the Missouri Plan. In the Missouri Plan, state judges, many of the state judges are elected, like the district court judges, for example. But in Oklahoma, for the Oklahoma Supreme Court and the Court of Criminal Appeals, which are our highest courts, a governor will appoint someone, and then we vote to retain that person after a period of years. So, like, for example, Governor Fallin might appoint a person to the court, and then we could go in and vote later, like 6 years later, should we keep them, should we throw them out? It's not a purely elected system, nor is it a purely appointed system, and that's a good way to blend appointed and elected to get the best of both worlds. All right, so The state of Oklahoma is divided into judicial districts, and we're here in Pontotoc County. We're in the 8th district, and so one of the 9 judges is specifically supposed to be looking out for us. Excuse me. The Oklahoma Supreme Court, this is a little bit out of date. We've seen a little bit of this, but I wanted you to see, this is in their courtroom in the state capitol building, and you see these curtains back here. When they're ready to come out, they all pop out from the curtains at the same time because they couldn't decide who would walk out first, so now they all just walk out together. So isn't that nice? It's a beautiful room if you haven't been there. And you might know of Rudolph Hargrave. He's the speaker who was on campus not too long ago. He has done a fantastic job. He just retired. He did a fantastic job of representing our district. And in fact, one of the things he said that I liked the most, and he said it the first time I ever heard him speak, and he said it again when he was speaking at East Central. When you write an opinion, first you write it so the judges will understand, then you want the lawyers to understand, then you make sure the people can understand. So he knew that when the Supreme Court writes its opinions, they were writing them not only for legal parties, but also for all of us to consume as our documents of democracy. Okay. Kind of turning the page a little bit here, kind of going to a new topic here. Jurisdiction is the authority of a court to act. So the authority of a court, whatever it is, over what subject matter they can hear, over can I hear a case. So I broke this down in this this little division here. We've got state versus federal versus tribal. We've got trial versus appellate, and then we have civil versus criminal. So we have these 3 different ways we are going to talk about dividing jurisdiction here. And this is a superb graphic. You might want to jot this in your notes here. We, in Oklahoma and any other state that has a significant Native American population, we, in essence, have 3 court systems side by side by side. Because we have the tribal courts, we have the state courts, and we have the federal courts. And they all are coexisting. On top of that, the tribal court, the state court, and the federal court can all be divided into 2 different types of cases, and this was on the previous slide, civil versus criminal. Okay. So civil cases would be individuals versus other individuals. So if I wanted to sue my landlord, me versus him, that's a civil case. If I got arrested for murder and the state charged me with murder, that would be a criminal case. That would be the state versus me, an individual. So for the most part, cases between individuals, people hurting each other, that's civil. But if it's going to be the state is charging you with something, then it's a criminal matter. I could go on for hours about this. There are whole classes. You could get a whole degree in this. I don't want to spend too much time talking about it, but it's important for a point that's coming up in a minute. Okay, and then the other distinction I want to mention right now is the difference between a trial court and an appellate court. So if you ever watch the law shows on TV, like Matlock, for example, Matlock is an attorney in a trial court. He is presenting evidence. There is a jury. The trial is there to determine whether someone is guilty in a criminal setting or if they're liable in a civil setting. That's what the trial court does. It looks to see if someone is guilty or if they're liable. That's the issue in a trial court. I'm going to write it down because it's so important. So in a trial court, the issue is defendant, I'm going to just say D, is defendant liable or guilty? Okay, so if it's a civil matter, they're liable. If it's a criminal matter, then they're guilty. That's what the trial court does. The appellate court has a wholly different job. The job of the appellate court is to merely answer the question, did the trial court make a mistake? So one way to think about this is the trial court really looks at what happened. What are the facts? The appellate court looks at, was the proper process followed? Were the right instructions given to the jury? Was the right evidence allowed by the judge? That's what the appellate court looks at. Did the trial court make a mistake? Okay. One other thing I want to point out is you might notice over here the Supreme Court is drawn separately than the rest of the federal court system. That's because in the state, if you're here at the trial court level, you're found guilty. Ooh, that pisses me off. I'm gonna appeal. And you appeal up to the district court level. Oh no, you're still guilty, and you can go all the way to state Supreme Court. They have to take your case, meaning they cannot elect not to take your case. 2,400 cases decided each year by the Oklahoma Supreme Court. That's a lot of cases. They can't decide not to take it, so they have to take everything, so they have that many. The U.S. Supreme Court, there are about 6,000 cases that are appealed to it, but are even more maybe now. But they only take about 50 cases. So the reason I drew it separately is to indicate this idea that the U.S. Supreme Court can decide not to take most of the cases that are appealed to it. A lot of people say, I'm appealing this case all the way to the U.S. Supreme Court. Well, if you're saying that, you probably don't have a very good case. You're just extremely stubborn. So the court doesn't want to hear all those cases. It only wants to hear the cases that are relevant to a lot of different people. So that's why I drew that separately. Okay. To say just a couple words more about the tribal court distinction, any one of us, even if we're not Native American, if we were caught doing something on tribal land or we'd married a Native person, we might find ourselves subject to the jurisdiction of Chickasaw courts or the other courts that exist in the United States. There are over 500 tribes in the United States. Chickasaw Nation is located here in Ada, and their building is actually up on Mississippi. And this, you can see in the picture, it's a gorgeous courtroom. They have two courtrooms. They have a Supreme Court that's an appellate court. They have a district court that makes lots of decisions. The divorces are one of the biggest things in the district court. They also have something that isn't found in non-tribal courts, which is a peacemaking court where a group can come in or a couple can come in and they can have their dispute. They can just talk about it. The way it works is you sit at the table, the speaker has an eagle feather, and then they pass that feather around, and only the person with the feather can be speaking. But you have to stay in the room until you make a decision, and when you come out of the room, you tell the judge, this is what we're going to do. This is how we worked it out. And that decision is actually legally binding. So it's very interesting that Chickasaws do that. And so, anyway, the woman you see in this picture right here, she's a graduate of East Central. She's the Chief Justice of the Chickasaw Court. And this is also a graduate of East Central. This is Dustin Rowe, who just got sworn in as a new district court judge. So very interesting stuff. Okay. What about double jeopardy? And this is sort of important because we have all these different types of jurisdiction in the United States. Like I said, we've got our tribal jurisdiction, we've got our state jurisdiction, and we've got our federal jurisdiction. We've got criminal versus civil. You could be tried 6 times for the same act. Well, how is that possible? For example, double jeopardy. It says you can't be tried twice for the same crime. Okay, true. You can't be tried twice for the same crime by the same sovereign. You can be tried in tribal, civil, tribal, criminal. You could be tried in state, civil, state, criminal. You could be tried in federal, civil, federal, civil, federal, criminal. You could be tried 6 times for the same act. You can picture O.J. Simpson. He was, I know for a lot of you this is ancient history, but O.J. Simpson was accused of killing his ex-wife and her boyfriend. The prosecution alleged in California that he had committed these murders, and for them to get him convicted, they had to prove such under or beyond a reasonable doubt. He was acquitted in state court in the state of California. Free man, right? Well, wrong, because the estates of the deceased parties sued him for the wrongful death of these parties. So he was found liable for their death. He was found not guilty of murder. That's pretty weird, isn't it? Well, the reason he could be tried twice is that double jeopardy doesn't apply to civil matters. It's only a criminal protection. In addition, you're thinking, well, what's the difference here between what was done in the civil court and what was done in the criminal court? If you're going to be tried in a criminal court, the burden of proof that the state must prove is beyond a reasonable doubt. BRD, beyond a reasonable doubt. To be held liable for something in a civil matter, you only need to be shown to be responsible by a preponderance of the evidence. If you ask people what it means beyond a reasonable doubt, I would hope they said it would say something like, beyond a reasonable doubt to them would mean something like 99% sure that this person did it. If we're going to put you in jail or perhaps even a death penalty you, we need to make sure you're guilty. But if you're just liable for something, then maybe we'll take your money away. Maybe you'll pay a fine, but you won't go to jail. So a lot of people say the preponderance of the evidence might just be 51%. So what happened in the O.J. Simpson case, in case you were wondering, and I'm sure you were not, but I'm telling you anyway, is that the state of California could not cross the threshold to get up to beyond a reasonable doubt. However, Ron Goldman and Nicole Brown Simpson's families did prove that Simpson was liable with a preponderance of the evidence. Ta-da! Doesn't that just solve a legal mystery for you? I'm so glad. Okay, turning the page again, turning the corner again. How the Supreme Court decides. Now remember, I drew that little diagram and I showed you that there was a division between the federal court system, which is like federal district court, court of appeals, and then going up to the Supreme Court, CT, Supreme Court, meaning CT court. Okay, I know that Supreme does not start with a C. Okay, so the first thing that the Supreme Court has to do is it has to grant its writ of certiorari. If you want to go to the Supreme Court, what you have to do is ask the court, please, sir, may I come to the Supreme Court? Once you file your writ of certiorari, the court reviews it and they decide if they want to let you in. Okay, when the court is deciding, they use the rule of four, which means 4 people have to decide that a case should be accepted. So people have to kind of want to hear the case before the court will accept it. All right, 4 people want to hear the case, the 4 out of the 9, and then that means that the Supreme Court has granted certiorari or granted cert to that issue. Okay, so once the court grants cert, it tells the parties, yes, we want to hear your case, you need to brief the issues for us. Each side will brief the issue. Legal briefs for the court, they might be 50 pages. They're an outline of all the legal issues. The court reads those briefs. They try to figure out what's going on in the briefs, and then they schedule an oral argument. Oral argument will last 30 minutes on each side. They'll pepper the attorneys with questions, and it's a time for them to clarify the legal issues that they might have. The next conference where they sit and they consider the briefs, they consider what they heard at oral argument, they argue with one another to decide what they would like to decide. And once again, 5 people have to be on the same page or else they cannot make a decision. Once they are in agreement as to how they will decide a case among these 9 people, the opinions are circulated among the justices. So if I was the Chief Justice and I was going to write the opinion, I'd write out what all the people who were in my coalition thought, and I would circulate those folks to make sure that it reflected accurately what they really did think. The final coalitions are established, make sure you say what everyone wants you to, and then you announce your opinions to the public. So it's a 7-stage process here of picking the case, deciding the case, and announcing the case to the public. So we as the public, where are we going to find these cases? Well, there's a lot of websites such as findlaw.com. With the proliferation of these sites on the internet, you can get Supreme Court opinions a dime a dozen. It's a lot different than it used to be, like when I was in law school before the internet was invented. Now, when I was in school, all we did was we went to these reporters, which is these reporters, the kind of books you'd see on the shelf in Law and Order, these are called reporters because they're reporting out the opinions of the court. So Supreme Courts, federal courts, state courts, they all have different sets of reporters that tell us what the courts have held. I've done a little research. I'm going to just quickly go over this. That when the Supreme Court writes an opinion, for it to be a good law, I just have an opinion that the Supreme Court decision should be really easy to understand. It should be very clear. So in the best case scenario, it should say, here's what we decided. This is the opinion of the court. I've seen cases in the last 10 years or so, literally, where this is what the caption at the top says. To figure out what the court is saying, you would have to go through each paragraph and count and understand whether or not that was actually the law of the land or just something that only 3 or 2 justices agreed upon. Sometimes we even have cases where you have 4 judges on one side, 4 judges on the other side, and then one person in the middle, and Sandra Day O'Connor used to do this all the time, where she would say, well, I kind of agree with this side on this issue, and I agree with that side on that issue. And so the only person who was even studying the law at all was O'Connor. So very crazy. It's very crazy when that is the opinion. And why is the clarity of opinions important? Because how to know what the law is if they aren't clear about it? Believe me, people are looking for loopholes on these things. The law needs to be crystal clear if we're going to expect people to follow it. So when I was doing my research, I looked at complexity, and the way I measured complexity, I looked at the number of opinions per decision. I looked at how complex their words were and their vocabulary words. I looked at their reading ease and how long the opinion was. And this is just kind of trivial now, but I just want to show you how Supreme Court opinions have changed. Look how back here during the Warren Court era, they were pretty short. The complexity was pretty low. They were pretty easy to understand. But with the Rehnquist Court, they've gotten more and more and more complex, and that's no good for American democracy. Okay, all right, changing the topic once again. This is the last section of material, so bear with me. I know this is an extremely long lecture, and I apologize. It's because I'm so passionate about it, and I love it so very much. Okay, this is the last bit of information. How do the judge make the decisions they make? 2 dimensions. Political ideology, which I know, other than knowing about that there are liberals and conservatives, I know we haven't talked about ideology. I promise we're going to do it in the next chapter. But political ideology, the Democrat, Republican, liberal, conservative, that's part of it. And then the other part of it is how the judge sees their judicial role. So judicial role can be conceived as either judicially active or judicially restrained. So if you're judicially active, you're willing to overturn cases, and you're willing to overturn laws, you're willing to overturn what's gone in the past. For example, when Rudolph Hargrave was speaking to the class this spring, he was asked to review a federal law to determine whether he thought it was constitutional under the U.S. federal Constitution. And he said, it was a federal law, and here was an Oklahoma judge making this determination. Well, he realized that the law was unconstitutional, and he said so. Some judges would just kind of wring their hands and say, well, if the legislature wants to do it, they should be allowed to do it. Who am I to say? And so Hargrave was an activist judge. He was someone who was going to rule a law unconstitutional because he felt it was. A restrained judge would not have ruled that law unconstitutional no matter what it said, and a restrained judge would be a lot more interested in following the cases that had gone before, following the past precedents. Okay, let me give you a brief history of the judges on the court. This is Earl Warren. He was Chief Justice between 1953 and 1969. Earl Warren was judicially active and politically liberal. He was a very liberal politician, very liberal judge. He was very comfortable overturning acts of Congress and overturning laws that were made by the states. President Nixon, who was at the time, was getting a lot of heat for the kind of decisions that Warren was making. For example, with the Miranda decision, he was expanding the rights of the accused. Well, people don't really like the accused that much, and so Nixon didn't want Warren to be so nice to the accused, so he was sort of against the kinds of things he was doing, and he looked for a judge to replace Warren with that would actually start to overturn some of the decisions that had been made by the Warren court. Nixon picked to be the Chief Justice a new man named Warren Burger. Warren Burger was Chief Justice between 1969 and 1986. Warren Burger, despite having these awesome pink chairs, was judicially restrained and politically conservative. So he's opposite of Warren because he's judicially restrained and active. He's also opposite because he's politically conservative, and Warren was politically liberal. Nixon wanted him to overturn Warren's cases, but he couldn't do it. And why couldn't he do it? He couldn't do it because he was judicially restrained. He saw his judicial role as upholding past cases. So instead of overturning the Warren court decisions, he actually followed them and in some cases extended them. And Nixon was just going nuts because the whole point of appointing Warren Burger was to make sure that these opinions would get overturned, yet Burger that's not how he saw his role as a judge. He wouldn't do it. Okay. When Warren Burger retired, he was replaced by William Rehnquist. William Rehnquist was elevated to Chief Justice on the court starting in 1973. He proved that he was extremely activist, he was extremely conservative, and Reagan liked his style. So Reagan elevated him to Chief Justice in 1986. And Rehnquist was like, all right, have at it. He would overturn anything because he was so firm in his judicial role of being an activist judge who would overturn precedent to preserve his conservative principles. So he's judicially active, yet politically conservative. Currently, we have a new Chief Justice. We have Chief Justice John Roberts, and he's only been on the court for 6 years, and I know that seems like a long time, but in judge life, that's hardly anything. We really don't know how he will be throughout his entire career. He's definitely politically conservative, but he doesn't seem to have the sweeping activism that you would have seen under either Warren or Rehnquist. But there was a very strong case that he overturned a direct precedent on. In 2000, there had been a case that banned partial abortion. Supreme Court struck it down, said it was unconstitutional, and then in 2005 or 6, the same exact case came up, exactly the same, and Judge John Roberts was willing to strike it down, even though if you're going to follow the past cases, follow the precedent, he should have upheld it. But he was willing to be activist on that one point. So that indication that he might be activist, but in kind of a narrow way. Well, this just goes back to this. I showed you this before, how if we're going to look at where the current judges fall, we're going to see a lot more conservatives over on this side, and the current Chief Justice is over here as well. This axis shows us the difference between being active versus being restrained, as well as the difference between being liberal and being conservative. These are two different dimensions in how judges make decisions. Are you a liberal or conservative? That's one dimension. That's ideology. And then the second dimension is judicial role. Are you active? Are you willing to overturn past cases and past precedents? Or are you restrained? Do you follow those past cases and past precedents? So we've seen a couple of good examples. Earl Warren, definitely judicially active, very liberal. Rehnquist, also active, however, more active in a conservative direction. And then Roberts, we see here, where he's been fairly judicially constrained and conservative. And this is also where we would put our friend Warren Burger. So, anywho, let me just run through a real quick example. I know this is extremely long, but I understand this will just take a second. Griswold versus Connecticut, 1965. One of the biggest cases under the Warren Court. Couple in Connecticut sues for the right to have birth. It was illegal in Connecticut to this point. They say they have a right to privacy. Under what constitutional provision? Well, they don't care. They just have this right to privacy. Make one. The Warren Court basically made a right to privacy and called it a fundamental right. That is an example of an extraordinarily activist decision. Very, very activist decision. They created a right to privacy out of thin air, basically. We'll talk about that case later in the semester. Here comes Roe versus Wade, one of the most divisive Supreme Court opinions in the history of the United States. Warren Burger's sitting on the court, super conservative guy. However, because he's more judicially restrained, he felt that he had to follow the precedent that was set in Griswold. Does he believe in abortion? Absolutely not. But his judicial role caused his hands to be tied in a way that he, in a very restrained way, followed the precedent set by Griswold in upholding a woman's right to have an abortion. So, in a sense, this could be an activist opinion because he's creating a new right. He just felt like there was no other way around it. He had to follow Griswold, and if you're following Griswold, that means you've got to have Roe as well. So, in the next instance, we have the Rehnquist Court dealing with another abortion case that's similar to Roe versus Wade. They wanted to overturn it. They almost did, but basically they just increased restrictions on abortion. Now, Rehnquist hated abortion. He wanted to overturn it. He would have done anything he could do to overturn it, but he pushed the court as far as it would go and restricted abortion in every possible way it could. But basically, they ended up holding abortion was still a fundamental right, but you could not unduly burden a woman's right to choose to have an abortion. So you could restrict it, but you couldn't ban it. Okay, I know there's a lot to digest there. There's tons of information in this chapter. It's all really important stuff. One last point. This is the case I was talking about with the partial birth abortion. The Roberts Court had a clear precedent. 2000, the Supreme Court had said this kind of law was unconstitutional, but in 2007, the Roberts Court changes the mind. This is almost unheard of for a court to go back on its word in just a few short years, but the Roberts Court did. So it's a clear comparison to the fact that Roberts seems to be even more activist on this point than Rehnquist was. All right, so in conclusion, a lot of stuff here. You got to know the members of the Supreme Court and how they are selected. You got to know about the 3 kinds of jurisdiction that we talked about. We got to talk about the process, the 7-point process that the Supreme Court uses to decide its cases, starting with the writ certiorari and ending with the reporting of the cases to the public. And finally, this last point, number 4, is about the internal thought processes that these judges use to make their decisions. Are they liberal or conservative? Are they active or restrained? So that's that. I know it's a lot. Let me know if you have any questions.